I'll be honest, when this lawsuit first landed, I assumed Eldon Leveris was just another ambulance chaser looking for a settlement check and a nice boat, a quick payday, a press release, gone by spring. That would have been almost refreshing, frankly. Simple, predictable, the kind of problem you can budget for. Turns out I was wrong, and not in the fun way. This man is not hunting for a payday. He is using my district as a lever to renovate an entire industry, and he is doing it so calmly it's almost rude. I'm Arthur. I run this district. Here's his whole plan, straight from the man himself. And I'd brace yourself, except I think you'll find he doesn't raise his voice once.
People like to call me a predator. I find that reductive. A predator wants lunch. I want structural reform. I just happen to bill for it. Let's clear something up, because people keep picturing me as some kind of avenging fury. I'm not. Thanks to the Supreme Court's Osseo ruling, I don't even need to prove Arthur acted with malice. I don't have to show he woke up one morning wanting to hurt these kids. Which is convenient, because I've met Arthur, and I don't believe the man wakes up wanting anything beyond a slightly shorter commute and one uneventful school board meeting. All I need is deliberate indifference. That means I show he knew about the problem and did nothing meaningful about it. It is, and I say this with real affection, an embarrassingly low bar. It's not even a bar, it's a curb, and Arthur has been tripping over that curb in a district-owned sedan since the day he signed the purchase order. Here's the part he hasn't grasped yet. I followed the checklist is not a defense to I knew and I did nothing. Those are two very different sentences. One of them sounds responsible. The other one is what actually happened, and only one of them holds up in front of a judge. I'll give you a hint. It's not the checklist. Right on schedule, the moment my filing landed, Arthur did exactly what I expected. He panicked and then, because panic needs somewhere to go, he delegated it downhill. Top-down mandate. Every teacher in the building now manually rewrites the lesson for any student who can't use the platform as designed. Print a simplified worksheet. Record an audio summary. Build a separate visual aid from scratch on their own time for one child because the software won't, and then document every single one of these workarounds in writing so the district has proof it was trying. He believes that's a shield. It is technically made entirely of paper. Historically, not a strong shield material. This shield is a confession, typed up and time-stamped for my convenience. Every time a teacher scribbles a workaround because the platform can't serve a child with autism or sensory needs, that isn't damage control. That's evidence. Evidence that the district knew the tool was broken and chose to ask the staff to fix it for free over fix the tool. If a child has to leave the general classroom just so someone can staple together an accessible worksheet at midnight, I don't call that an accommodation. I call it segregation with a paper trail. People always ask why I don't sue the software vendor directly. Because that's a war of attrition against a company with more lawyers than I have client meetings. They can bury a case in appeals for a decade and barely notice the legal bill. Districts, on the other hand, are the customers, and customers have leverage vendors don't expect. Most of these publishing contracts include compliance and liability clauses, language saying the district can walk away if the product turns out to violate federal accessibility law. Nobody reads that clause when they sign. It sits there for years, doing nothing, like a fire extinguisher nobody's ever had to use. The moment I sue the district, that clause stops being decoration and starts being a loaded exit ramp the board's own attorneys will point to. I'm not going after Goliath directly. I'm convincing Goliath's best client that the contract itself gives them a way out, and once they take it, Goliath has to answer to someone. It's a very unglamorous way to slay a giant. No slingshot. Just a strongly worded liability clause nobody bothered to read in 2019. When a school board is staring down a federal lawsuit, they don't quietly eat the loss. They pull out the contract. They find the exit clause I just mentioned. They start making calls to the publisher asking, politely at first, why they're still paying for a product that just became a legal liability. That's the lever. It has always been the lever. It just usually shows up wearing a different letterhead. I'm not suing this district to bury it. I'm using it to renegotiate an entire industry's incentives because publishers don't build accessible materials out of the goodness of their hearts. They build it the moment their biggest customers threaten to leave. Arthur believes he can survive an audit by running his staff into the ground, which is an impressively optimistic plan for a man who needed outside counsel to explain what accessible means in the first place. He's mistaken, and I have the login logs to prove it. Records showing the district knew the platform was inaccessible to specific students and kept the contract running anyway. That's exactly the kind of new and did nothing evidence the Osseo standard was built for. The only way out now is a full redesign. He simply doesn't know that yet, but he will, probably around the third deposition.
Cool legal theory. Genuinely. Very smart, very tidy. I'm sure it reads beautifully in a filing. Here's what it looks like from my side of the building. 7 kids, 30 minutes, and a login screen that hates all of them personally. So, spoiler, I did something about it. I locked every Chromebook in this building in a steel cart, snapped the padlock shut, and walked away like a man reclaiming his life. The school board does not know yet. I'm telling you first. Stick around. Next time, I explain exactly what pushed a reasonably sane teacher to stage a one-man rebellion armed with a dry erase marker. Subscribe. You're going to want to see this one.